That is right, Judge. Thank you for saying that. You don't get to substitute your decision-making for the president's. There are consequences to these firings, and a lot of people are not in good spots right now. Thus, the unions estimate that the termination of all non-essential employees, would cause the unions to lose $15 million, or around 38% of all its annual dues revenue.
$33 billion for Rosa DeLaRusa, Jerry Connolly, a lot of folks know him, $59 billion, and the leader himself, Hakeem Jeffrey, $91 billion. Wow. Look to their state.
There is a pattern afoot. Another big victory for President Trump. This one brought by the National Treasury Employee Unions against Trump. Of course, when Trump wins, the rest of us win because he's executing our will through the power of democracy. But you can see this came out of the District of Columbia. This comes right after Judge Carl Nichols also issued a memo dumping another set of union cases that should have been dumped. He said, you guys are here complaining about being fired. Those are employment complaints. You got like 5 other boards you can go use to file your complaint there. Don't bring it into this court and demand a TRO or a preliminary injunction to try to stop the executive branch from doing their job. That was one. Now we got another one. We're seeing a pattern emerge. This is good news. You can see this case came out from the Treasury Union against Trump and the Treasury Department. And the judge wrote this, says, look, the first month of Trump's second administration has been defined by an onslaught. That's right. Don't you forget it. It's been one hell of an onslaught. We're just warming up, cracking knuckles. Kash Patel just came in. That have caused, some say by design, disruption and even chaos in widespread quarters of American society. It's affected citizens, and their advocates have challenged many of these actions on an emergency basis in this court and others. Certain of Trump's actions have been temporarily halted. Others have been permitted, at least for the time being. Now, these mixed results should surprise no one. Federal judges are duty-bound to decide legal issues on an even-handed application of the law, no matter the identity of the litigants or, regrettably at times, the consequences of their rulings for average people. That is right, Judge. Thank you for saying that. You don't get to substitute your decision-making for the president's. There are consequences to these firings, and a lot of people are not in good spots right now. I think they'll be in better spots when their lives are more productive, not working for the federal government, but they might disagree with that. But there are consequences for us in not making these reforms. So we have to always keep that in mind. But the judges don't get to substitute their judgment for Rubio, for the State Department, for USAID, for the Treasury Department, for the will of the American people. This case presents challenges to 3 of Trump's recent executive orders that were aimed at drastically reducing the size of the federal workforce. The unions are the National Treasury Employees Union and 4 other unions that represent federal employees. They all came in seeking a TRO and a preliminary injunction. Again, they're kind of the same thing, just at different stages. One is like urgent, and then you want to see if you can formalize it to prevent the termination of their members, right? They said, you can't fire all these probationary employees, and there are a bunch of probationary employees just gone immediately because they can't. They wanted to stop it. They said, you have to stop the implementation of a large-scale RIF, reduction in force, across all federal agencies. And you have to stop the renewal of the administration's program that was the deferred resignation with pay. So cancel his fork in the road program. Now, for the reasons explained below, this court will deny the unions the preliminary relief they seek because it likely lacks subject matter jurisdiction to hear your claims. The claims must be brought through the FLRA, Federal Service Labor Management Relations Statute. Go complain somewhere else. On January 20th, the OPM, Office of Personnel Management, often thought of as the Office of Other People's Money, which is our money that they siphoned off into Lord knows where, issued a memo directing federal agencies to identify all employees on probation. And remember, it's not like, bad probation, like you got convicted of a crime and now you're on probation, or you did something bad, so you're on probation. It's like you just got hired, brand new job. So you're on a probationary period to make sure you're kind of competent. Of course, federal government's standards are, what they are. It says probationary employees less than 1 year or less than 2 years in accepted service appointment. Agency heads were directed to send a list of all these probation employees to OPM, and we're going to determine whether we want to retain them here or not. They also requested a determination from each federal agency as to which probationary employees they wished to retain, along with a short justification. And I think it was like 200 characters. Okay, it was like a small form. It's like you start typing, I'm amazing, I did this, and it's like, you're done. What? I got like 2 sentences. What? Justify yourself quickly. The federal government employs an estimated 220,000 probationary employees. It's so many people. NTEU says they allege that a mass firing of probationary probationary employees is now underway. It is, they say, but the allegation is not without evidence. Here, right? They got plenty of evidence. On February 11th, the Consumer Financial Protection Bureau sent pink slips to its probationary employees. The FDA and the Department of Energy have cashiered well over a majority of their probationary employees. So FDA, nuked. DOE, nuked. Health and Human Services, Bureau of Land Management, BLM, EPA, National Park Service, FDA, also sacked many probationary employees. FDIC, IRS, they're also intending to do the same thing too, and that's happening imminently. The IRS is apparently planning to fire thousands of probationary employees as soon as this week. That's good. Meanwhile, on January 28th, the OPM, Other People's Money, sent an email to all federal employees presenting them with a deferred resignation known as fork in the road. The original email went out. We read through some of it. Now, under the terms of the offer, employees who choose to resign would retain all pay and benefits regardless of their daily workload. They would be exempted from all in-work requirements until September. Take the buyout, go on vacation, get a new job. To resign, all employees needed to do is just respond to the email with one word: resign, and then get out. The fork in the road email further noted that OPM could not give full assurance regarding the certainty of your position if you choose to stay. So it's your choice. But if you stay, you might get fired. It's like Hunger Games or something. As originally announced, the opportunity to accept the offer was set to expire. Prior to the deadline, a bunch of whiny unions representing a bunch of whiny federal employees who are civil servants sue their own country who says, we can't afford you. They sue us saying, I'm a great civil servant and you're going to like my service. You're going to like my servantness to you with this lawsuit. And I'm demanding attorney's fees too. You're welcome. The employees moved for a TRO asking for a stay of the February 6th closing. On February 6th, another judge, George O'Toole, entered a TRO, said the government, you cannot fire people at the end of the fork in the road deadline. Then on February 12th, Judge O'Toole dissolved the restraining order, denied any further preliminary injunction relief because the unions did not have standing to challenge the program, and the court lacked subject matter jurisdiction over their claims, right? Another judge says, guys, why are you suing? You're a union. Have your union members sue. The program subsequently closed on February 12th, as we saw, and all further resignations were no longer accepted. You made your bed, now you can sleep in it. Says, according to the White House, approximately 75,000 employees, roughly 3% of the workforce, resigned. They took the deal. So then, continuing the push to slash the federal workforce, Trump issued another executive order. That executive order included several directives to supposedly eliminate waste, bloat, and insularity in the federal government. It's true, get rid of them. Says, relevant here, the order directs agency heads to conduct a RIF, a reduction in force consistent with the law that your agency has, and separate from federal service temporary employees or reemployed annuitants working areas that are going to be subjected to the RIF. The order also says offices that perform functions that are not mandated by statute or other law have to go. If it says we have to keep it, keep it. But if it's like discretionary in any way, that's going to be prioritized in the RIF. And you know what those agencies are, or what those little divisions are? Diversity, equity, and inclusive initiatives. Any of those components are suspended or closed, and all components, because they're not mandatory, and employees performing functions that are not mandated also needs to go. So then they say, oh my goodness, Judge, they fired us. They say that they fired over 70 term employees from this, and many of these people are our members too. So the 5 labor unions all sued. The NFFE, the IAM, the IFPTE, the UAW, all sued. The unions brought constitutional and statutory challenges. You can't fire us. You can't give us this fork in the road. You can't issue this executive order. Who do you think you are? The President of the United States? They claim that these executive actions violate the separation of powers principles, which they obviously don't care about because they're asking the judge to usurp the executive power. They say they undermine Congress's authority to fund the mission of federal agencies. Yeah. They further claim that the challenged actions violate the statutes and the laws. You can't just fire all these people. Each union has dues paying members, and they're going to be impacted. To date, approximately 1,250 to 1,500 dues paying members have been fired. That represents more than $500,000 in revenue to the unions. Isn't that fun? They're like, well, we lost $500,000 because they're not going to pay our dues because Americans aren't employing them anymore. Isn't that great? Everybody's in on the grift, and we're always the ones getting screwed. 94% of members pay union dues via payroll deductions. Comes right off the top, skims right off the top. So dues members, for these members who have been terminated, stop with their final paycheck. Isn't that sick? That's why they're suing. They don't care about these employees. They care about these employees' paychecks and skimming a little portion right off the top. The IRS in particular employs more dues paying members than any other federal agency or department. HHS also accounts for a large number of members too. Thus, the unions estimate that the termination of all non-essential employees, would cause the unions to lose $15 million, or around 38% of all its annual dues revenue. Isn't that interesting? We pay the employees via our taxes, and as a member of the federal government, they join these unions for whatever reason, like they're not ever fired. I mean, it's like, this is why they're all freaked out about this, like first time ever they've been actually fired. What? The unions skim $15 million a year off the top of this. Huge portions of that money from the unions goes right back into Democratic coffers, goes right back into Democrats, literally. So they're all just getting paid. That's our money. The NFFE, for its part, has thousands of dues-paying members who are probationary at the U.S. Forest Service, who the termination of them, they can't maintain their membership. Why should they be a part of your union at all? To collective bargain against the government? But the IFPTE also has some dues-paying members who are also going to be fired. The unions filed their complaint 2 days later on Valentine's Day, no less. They moved for a TRO. They're like, we love our country. We are civil servants, but we're suing you for everything you've got. Saying, you must hire us back. You can't fire probationary people. You must extend the fork in the road and more. The court got the case on the 15th on a Sunday. That same day, ordered immediate briefing and oral arguments. Then the unions amended their complaint, saying even more people are being fired at Department of Ag, Food, Nutrition, and more. Firing people across the board. The court held a hearing on the 18th. And so now the court will deny these unions and their motion. It lacks subject matter jurisdiction over the claims. Like, this court is the wrong court. You cannot sue for this here. They must pursue their challenges instead through the scheme established by Congress under the Federal Service Labor Management Relations Statute, FSLMRS. That's where administrative review happens for these things. And if you don't like what their result is there, you can go through the Court of Appeals. And this is 2 for 2 now. Actually 3. We've got several of these stacking up. It's basically they have no standing. There's no jurisdiction here. You're in the wrong spot. But these judges have been granting these for the last however many weeks, saying, look, a temporary restraining order like a preliminary injunction is an extraordinary remedy. We can't just hand these out willy-nilly. When considering these things, we got 4 factors: success on the merits, irreparable harm, equities, and public interest. The court considers these in turn. It says, first of all, the unions failed to establish that they're going to win. We don't even have subject matter jurisdiction. So we're going to deny this and deny their request for a TRO and their request for an injunction. We don't even need to address these things. Let me just explain why I can't hear your case. Here's some background. This law was created back in 1978. It says federal employees can organize and bargain collectively against the federal government. It requires that unions and federal agencies negotiate in good faith, establishes a scheme for administrative and judicial review, like their own internal courts. 3-member agency adjudicates these things. There's negotiability. It's encoded in the U.S. Code, and they resolve these things. Direct review of these decisions. So if you're unhappy with that, you can appeal. The D.C. Circuit has held this scheme is the exclusive procedure by which federal employees and their unions may assert these claims, right? And these unions knew that too, but they just wanted to sue to gum up Trump. Separately, the CSRA, and they, how much time and money this cost us. These people are scammers. Separately, the CSRA also established a comprehensive system for reviewing personnel. You can go through any of these processes. They knew it, but they sued anyways. Trump's government says you can't hear these claims because this is preclusive. The court employs the framework set out in Thunder Basin, saying the test is ultimately, if you go through another agency and you're not heard in this court, are you going to get a fair shake? They say, let's find out. Now, the unions don't dispute that the claim are the general types of claims that the Congress set up. It's about labor. That's set up to handle labor. Will you get a meaningful court appearance? Like, will you get due process and judicial review? Yeah, you will. They say that we won't. So they say it's here and now, but they can get a hearing. The harms don't resemble injuries elsewhere. They don't claim that the statute is unconstitutional. And so their assertion that it cannot recover its relief doesn't change the court's analysis. That might be true, but you can go through them. You have to make that claim there if you're going to get compensation or damages or whatever. Take it to them. They say that there's a constitutional challenge that they can't help us recover, but if absent any challenges to the procedures that they want to circumvent, I can't hear the claim. You got to go through there and say it's unconstitutional over there. Saying the Supreme Court explained that whether a claim is precluded turns on the type of employee and the challenged employment action. So this court's precluded from hearing it. You got to take it through the right forum. At bottom, the union's argument sounds in practicality and efficiency, but the DC Circuit was unpersuaded by this in another claim. There, they found the other area was more appropriate to hear this, and I can't hear it now. And so the court will deny the union's request for a TRO and for a preliminary injunction. And so it is therefore ordered that the the federal government workers unions, 5 of them, and their motion for a TRO and a preliminary injunction is denied. So ordered by Judge Christopher Cooper, another victory from the United States District Court in Washington, D.C. And that's another big victory. So there's still a bunch of other judges out there who have bad TROs on the books, but this is starting to be good momentum. Okay, these other judges overstepped themselves way too aggressively at the initial TRO stage. Now that these are getting scheduled for preliminary injunctions and the Trump DOJ is able to build out the record, we're seeing what looks to be like a reversal. So good developments over there. Now, we also saw this woman, Jasmine Crockett, is out very upset with Doge and all of these changes. And she was out on the Breakfast Club explaining that she doesn't really even care about America. She cares more about Canada and Mexico. Here's a little bit of Jasmine Crockett on this Friday.
Really been the one to call it out. The fact that I'm rooting for Canada and I'm rooting for Mexico a lot is really wild. But they are really the ones that are speaking truth to power right now. They can see what it is. And they were like, we are not messing with this crazy regime from Mar-a-Lago, and basically calling them thugs. That's what it is. But I'm like, y'all knew who he was when y'all elected him. So
we did. That's why we elected him. We did. We know who he is. We're pretty happy with the results thus far. So that was Jasmine Crockett. We also saw that Scott Turner is explaining that HUD and the Doge task force that is helping to clear this up have been de-obligated and sent back to the U.S. Treasury so that these funds can be better used for the American people. Here is the Secretary of HUD, Housing and Urban Development, Scott Turner, explaining.
You find $1.9 billion in misplaced funds. Those funds are actually supposed to be used for administrative services to administer the services we have here at HUD. So what should happen is that you notify the Treasury Department that these funds are no longer needed, and so you can return them to the Treasury to use for other federal expenditures. And so we will now, going forward, have internal processes and controls and take inventory of funds that are not being used. And with the funds we just found, the $1.9 billion, we've de-obligated them and turned them back over to Treasury so that they can be put back in the Federal Reserve to use for the American people.
Sounds pretty reasonable to have controls and checks and balances inside the agencies. People like Jasmine Crockett aren't interested in that. They're rooting, in fact, for other countries. Now, here is the reason why. Carly Bonney got this clip for us over from Fox News showing how the money flows back to the very people who are the most hysterical about the cuts.
$33 billion for Rosa DeLaRusa, Jerry Connolly, a lot of folks know him, $59 billion, and the leader himself, Hakeem Jeffrey, $91 billion. Look, to their state.
In politics, money is power. If you're getting money for your state, you're making your constituents in your state happy. That's who's voting for you. That's how you keep your job. So when somebody comes along, and Elon Musk famously on stage yesterday with the chainsaw, the point is he's there to make big changes. But the folks who count on the cash flowing year after year hate it. Now, they're going to have good reasons why they like all these spending programs. No doubt they're out there saying it. But the point is they don't want that system to change because that system works for them.
I understand that they're going to get pressure from the stakeholders in their state. But when I'm talking with people, average day folks in the country of all political persuasions, they like the cutting because they're wondering why they aren't receiving some of this, these funds.
There's an intuition, and it's right. This money isn't their money, and it's not the government's money. It's taxpayer money, right? Every improper payment, every check that goes to somebody who doesn't deserve it, every check that puts somebody on dependency for the government, taxpayers know that's their money, and they don't want to do that. They want somebody looking out for this, somebody who cares about what we call the improper stuff. That's Doge.
Professor, breaking it all down.
Doge in the House, right? And this is pork barrel spending. This is the same stuff that's been a problem in this country from the very beginning. Congress spends money and they support themselves. But the problem is there has been no transparency, and they think that they can spend their $59 billion or whatever they bring back to their states better than we can. And what they're actually spending it on is not improvement for their constituents or for the American people. It's improvements for their power. And the grift is up. We've had enough of it. We can't continue to fund it, and we're not. So what we see are major developments, and even the judges in D.C. are starting to sound a different tune. We're going to be here continuing to cover it, my friends. Thank you for subscribing and becoming a member to join us as we do.